Thank you, Vinay. Now I start with the session Azadi Ka Amrit Mahotsav, 75th anniversary of India's independence, India's state practice in public and private international law. I call the first speaker, Shri Anil Malhotra, life member, and Ankil Malhotra, to present a paper on India's state practice in cross-country interparental child removal. Okay, please, okay. So I invite Mr. M.K. Rao from the Legal and Treaties Division. On behalf of Ms. Uma Shekhar, she was supposed to be here, so he's going to present.
Yeah. Thank you very much, Professor Chawla, for giving me and also I thank Indian Society of International Law for giving me this opportunity. In fact, as said by Vinay, I am representing the Additional Secretary of the Legal and Treaties Division, Ms. Uma Shekhar. Unfortunately, she is not available. I think she is busy with the Indus Water Treaty, where the World Bank has referred the disputes between two disputes, Ratlam and Kishanganga, to a neutral arbitrator, which is taking place in Washington, D.C. The other process, legal process, arbitration process in The Hague. The Hague panel held Sheen Murphy, Professor Murphy, who is International Law Commission member. They held a preliminary meeting where India did not submit any, they raised a preliminary objection. So it's going to be considered in the next 3 months. So it seems she is busy with that. So unfortunately, but I did not prepare anything because this is the India's practice of international law. I saw the list of speakers and the topics. I'll just say a few words briefly so that our expert Malhotra ji and other experts will take over. And as I saw, the first speaker is Mr. Anil Malhotra, senior advocate, and he has been extensively practicing in private international law. He is a prolific writer. While I leave the subject to him on the private international law, the specific topic, but I would like to mention on private international law, our former Additional Secretary, Mr. Narendra Singh, is here. During his tenure, India has become a party to the Hague Conference of Private International Law at The Hague in 2008. And also, we signed and we accessed to the 4 international conventions adopted by under the auspices of Hague Conference. I will just quickly give you the titles of these things. The 1961 Convention, this is the so-called Apostle Convention, 1961 Convention abolishing the requirement of legalization of foreign public documents. So you don't have to, one single public authority will be there. He sits in the Patiala House. Once Apostle signs it, that will be valid without any further authentication, valid throughout the contracting parties to this particular convention. The second is 1965 Convention on the service abroad of judicial and extrajudicial documents in civil and commercial matters. The third convention is 1970 Convention on the taking of evidence abroad in civil and commercial matters. The fourth one is 1993 Convention on Protection of Children and Cooperation in the respect to inter-country adoption. These are the 4 conventions which India has ratified for the first time during tenure, late 80s, late 2000, during the tenure of Shri Narendra Singh. And in addition to that, I see the topics that practice of international law, practice of India in international law, and other thing also I see there is someone is going to speak on the India's cases before the International Court of Justice. We have so far had 6 cases, including the last one, Jadhav case, and also the Italian Marinas case initially. So these are the 6 cases we had, and also But otherwise, all other cases, we are mostly respondent. In India, Pakistan, India, the first one is on Portuguese, the so-called local customer internet, local custom that can be formed. That's the principle. And also, I don't know whether the speaker has come about the India's position, critical analysis of India's position in the Russia-Ukraine conflict. Is the speaker is there? Speaker on this, Gurpreet Singh. You are going to speak. I keenly look forward to listen to him. But one thing I must, last time we had a conference here. Some of the executive members of the Indian Society of International Law, of course, they're all professors. Now they spoke condemning the Russia for the aggression, all these things. They spoke about humanitarian law, all these things. But basic thing, what I think, and the scholars should understand, there was an understanding between NATO and the Russian Federation soon after the collapse of the Soviet Union that NATO will not be expanded towards the east. And now the Soviet Union has become 15 countries, and some of the countries slowly joining the EU and also joining NATO. First of all, we must understand, is the oral agreement, gentleman understanding, is binding or not? I know under the law, in the Vienna Convention, it should be in writing, but is it the ultimate law, ultimately binding law, binding? That one issue. There is another Budapest understanding. That was also an understanding whereby Ukraine has given up its nuclear weapons. That also now they are insisting, that's also an element which has to be taken into account for any bilateral, any kind of settlement between Russia and Ukraine. Of course, it's not Ukraine which is fighting war. It's entirely the NATO countries, mainly United States of America. How could United States of America give $100+ billions of dollars? Is it for good for nothing? And Americans say always, there are no free lunches. So I think one has to understand beyond what's happening and the issues, and from that perspective one has to analyze the things. I'm glad somebody is now going to prepare it, present it. I'm very keenly going to watch. But otherwise, I will, of course, with the permission of chair, I may keep any comments reserved. And I thank you very much for listening to me. Thank you.
Thank you, Rao sir, for the very wonderful introduction. In fact, you play a very pivotal role in India's movement forward. And I'm glad that you mentioned that India has joined the Hague Conference on Private International Law. We have signed the Adoptions Convention, we have signed the UNCRC, but the gray area is what we are going to talk about today. So friends, we are a corpus of over 30 million non-resident Indians. We live in more than 208 countries. We have huge cross-border migration. We are spread out all over the world. Our marital disputes have serious issues of rights conflicting vis-a-vis children are concerned. Now, when a child is removed across borders from one jurisdiction to another against the consent of the other parent or in violation of the rights of the other parent, according to Indian law, there is no wrong done. And the simple answer and reason is that the father or the mother doing so is a natural guardian, maybe Hindu law, maybe Mohammedan law, maybe Christian law, or maybe any other law. So because it is not statutorily defined as a wrong or an offense, either under the IPC or the civil law, we do not consider it a wrong. Now, we are apart from 102 countries which are signatories to the Hague Convention on Civil Aspects of International Child Abduction 1980. This is a multi-country treaty whereby you create inside the country a body called a central authority which regulates the children, movement of children from country to country. And once a court order in a foreign jurisdiction is passed, it is accepted by a signatory country and subject to a judicial process, the child is returned. The situation today is no foreign court will allow a child to come to India when there is a broken marriage. Because they say if a child is going to India, the child will never come back. The Americans are very agitated about this because under American law, it's a federal offense under the UCCJEA. Most European countries consider it as a wrong. Now, the Hague Convention on Civil Aspects of International Child Abduction says that willful removal or wrongful retention of a child is when a child is removed against the consent of one parent, when the other parent is exercising parental rights by virtue of operation of law or by virtue of some domestic law of the country. Now, though it is called Abduction Convention, in the entire convention, the nomenclature is all civil because the intention is not to punish the offending parent who has removed the child. So where are we in this process? Our law is all guided by what the Supreme Court says. So from time to time, the Supreme Court has leaned in favor of child removal and sent back children on the principle of comity of courts. Justice Lukur, in a very vast judgment in Suryavadanan, went very far in saying theory of first strike, whichever country takes cognizance first, takes on. He coined the principle of jurisdiction of closest contact and comity of courts. A subsequent judgment by Chief Justice Deepak Mishra in another matter watered it down, did away with the theory of first strike, cut out comity of courts, and only left the principle of jurisdiction of closest contact principle intact. Now, thereafter there have been different views, but ultimately the Supreme Court has now started returning children. Two major shifts have been seen. Gender preference has been done away by the Supreme Court. You no longer can say under Section 6 of the Hindu Minority and Guardianship Act, I am the mother, so the child's custody should go to me because the child is less than 5 years of age. Supreme Court says gender doesn't matter. And the next question which the Supreme Court has evolved is that if you have brought a child to this country and the child is habitually and permanently resident abroad, then the Supreme Court says it is in the best interest of the child to go back. Now, I have, because of the lack of a definition to child removal, arguing in the Delhi High Court and in the Supreme Court that we need to pick up the best interest of the child definition from Section 2, subsection 9 of the Juvenile Justice, Care and Protection of Children Act 2015. And happily so, the Supreme Court has done it. Why? We are a signatory to the United Nations Convention on the Rights of the Child. All the rights of the child in the convention have been incorporated in the JJ Act, which was amended in 2015. So per se, per force, JJ Act is not meant for juveniles in conflict with law or orphans or abandoned or surrendered children. They are meant for children everywhere. So this definition having been adapted, Supreme Court in a larger picture looks at the best interest of children, and if they find that the child's interest is more suited in going back, the Supreme Court has started openly now ordering that if the mother wishes to go back, it's her choice, we can't force her, but the children need to go back from where they came. Now, in this entire quagmire, we have an outdated, outmoded legislation, the Guardian and Wards Act of 1890, not 1980, but 1890. It is an antique piece of legislation drafted by the British to suit them, their own ends. And hopelessly, it looks at seeking single parent guardianship or single parent custody, which is in violation of all tenets of international law vis-a-vis children is concerned. The Law Commission, in report number 257 in 2005, Justice A.P. Shah very exhaustively looked at amending the Guardian and Wards Act, the Hindu Minority and Guardianship Act, and bringing in concepts of shared parenting and joint custody. But the amendments have never come across. So what happens? A child is removed from a foreign country, brought to India, and the mother or the father who has removed the child rushes to the court, the guardian judge, in a family court to seek singular custody. The other parent follows with a foreign court order. So we are in a mess. One side is the habeas corpus and one side is the guardianship petition. And decisions vary. And litigation goes at a snail's pace. So it takes 2 to 3 years before a decision can be finally taken. Now in this big mess, the efforts, salutary efforts of people like Mr. Narinder Singh, as flag bearer of late Ramnivas Mirdhaji, who inculcated us and who was a very passionate person in amending family laws, we strive for India to move forward and take a path out whereby we can fall into a system of law. Now the question which I put to myself is, if we can do it in inter-country adoptions, why can't we do it in child removal? After all, we allow adoption of children, irrespective of marital status, to any person subject to his qualifying the adoption regulations. And we have a very systematic method of putting everything into place by CARA being the central authority to regulate adoptions, and everything is streamlined. Why can't we do it in abductions? What is the difficulty? Should we continue to have singular custody concepts? Should children suffer in silence? Should children grow up to be with single parents? Why cannot we take a call? I have been working on it for almost 30 years now. We got very close to it in 2007 when Mirdhaji motivated, this was an international conference, and we had the Secretary General of The Hague, we had the Dutch ambassador, the British ambassador, and the Congress government agreed, but then the elections were announced, Parliament was dissolved, and everything fell back. But there was another development. I was an amicus for 12 long years in a matter removed from Punjab to England. This was a reverse removal. Before the judge demitted office, I gave him a report. We couldn't bring the child back. He referred the report to the government. The government in turn constituted a Hague committee, which was later known as the Bindal Committee. 6 honorable judges, 6 government officers, and I as a lawyer were in the committee. We did interviews for 2 years, talked to everybody, and we came out with a bill. That report and that bill hangs with the government. Again, we are back to square one. I think what we really need to do is we need to ask the Supreme Court in a given matter to lay down practice directions like we did in Vishaka. And over a period of time, it can happen that that will become a law. I, in 2 or 3 matters, was able to persuade the Delhi High Court and the Supreme Court to follow a mirror order principle. That is, if a High Court in India or the Supreme Court orders the return of children to a foreign jurisdiction, the order of the Indian court should be made a part of the foreign order. That is, mirroring the order. And with those sanctions which the Indian court requires for the spouse who has removed the children, those protections, the order can be incorporated in the foreign court order, and those protections can go across. The Supreme Court did it in Navtej Singh's case. It did it in Perry Kansagara's case. But Perry Kansagara refused to comply with the conditions. He has been convicted for contempt, and the matter hangs. But there is another bad side to it. Because we do not let fathers or mothers get access, the process of kidnapping has started. In Karan Goel's case, the father abducted his own daughter, went to Nepal, the US Embassy gave him shelter, and he smuggled the child out. We had Aman Lohiya's case, which I handled ultimately when he was brought back. He fled via Nepal to US, to Dubai, converted to Muslim religion, but he was brought back. So all this is leading from the frying pan into the fire. Should it go on? No way. When will the government make a law? We don't know. So I guess the only answer is, let the court lay down practice, Supreme Court lay down practice directions or some guidelines which uniformly get to be adopted and put in place. That's all I can say for the time being. Perhaps ISIL will be able to generate a momentum to make something going. And till then, we wait for the next conference. Thank you.